Well, the Trump for President campaign has a very bad day coming, the worst day any presidential campaign has ever had. And that day is scheduled for September 26th. The Harris for President campaign is now 46 days old, and every one of those days has been a bad day for Donald Trump. But the worst campaign day for Donald Trump is coming on Thursday, September 26th. Donald Trump is now formally scheduled to have the worst day in the history of presidential campaigning as we know it. He will be the first presidential candidate in history to have a federal prosecutor outline in detail, in writing, including possibly secret material from a grand jury describing Donald Trump's federal crimes that the prosecutor says Donald Trump committed to overthrow the will of the American people in the last presidential election. Federal Judge Tanya Chutkan ruled late today that on September 26th, Special Prosecutor Jack Smith must file his full evidentiary argument in writing about why Donald Trump can be charged with federal crimes, even though the Supreme Court created a new presidential immunity from criminal charges for some of what Donald Trump did to overthrow the election results. In a 1-hour, 14-minute hearing today in her Washington, D.C. courtroom, Federal Judge Tanya Chutkan dealt with a flurry of attempts by Trump criminal defense lawyers to delay any consideration of evidence in the case of United States of America versus Donald J. Trump until next year, no doubt in the hope that Donald Trump will then be in a position to order a new attorney general to drop the case. An appeal of the case to the United States Supreme Court earlier this year allowed Trump-appointed Supreme Court justices to create a brand new law of the land based on nothing in the Constitution, granting criminal immunity to Donald Trump for some of what he did leading up to and on January 6th. Special Prosecutor Jack Smith and his team, having now read the Supreme Court opinion, limiting what evidence they can present about crimes committed while Donald Trump was president, impaneled a new grand jury in Washington, D.C., which issued a new superseding indictment of Donald Trump, which preserved all 4 criminal charges against Donald Trump in the original indictment, including conspiracy against the United States of America, but eliminated some of the underlying evidence that supported those charges. Special Prosecutor Jack Smith obviously believes there is enough evidence in the superseding indictment, which is 9 pages shorter than the original indictment, to convict Donald Trump of the alleged crimes. In court today, Jack Smith's team, led by Thomas Windom, urged Judge Chutkan to first do what the Supreme Court has ordered her to do and evaluate the new indictment to see if it conforms to the limits imposed by the Supreme Court's immunity decision. Trump lawyers opposed that approach because that would force possibly public consideration of the evidence against Donald Trump before the election. Trump criminal defense lawyer John Lauro argued instead that Judge Chutkan should first rule on the defense's motion to completely dismiss the case based on the Supreme Court immunity decision. If Judge Chutkan ruled on that dismissal motion first, no matter how she ruled, that ruling could and would be appealed by the losing side, and it could be appealed all the way to the United States Supreme Court, adding possibly another year of delay to the case. That delay is not going to happen. Adam Klasfeld, who will join us in a moment, was in the courtroom today, and it showed us once again that a court transcript can never quite capture the full drama of what happens in the room. When Trump's criminal defense lawyer began his complaint about allowing any evidence in the case to possibly be revealed before the election, Adam Klasfeld, live tweeting the proceedings, reported this. Lauro warns about prosecutors being able to put into the public record at a very sensitive time in our nation's history, which we can't ignore. Chutkan let out a sigh and leaned back in her seat at that remark. Adam will describe that moment more fully for us, but here is how it appears in the transcript. Mr. Lauro, well, it's incredibly unfair in the sense that they're able to put in the public record at this time, very sensitive time in our nation's history, the judge, Mr. Lauro, which we can't ignore, that they're able to, basically load up on what they think this case is about without our ability to meet those factual assertions with the right to cross-examine. John Lauro will have the right to submit a written reply to the prosecutor's written description of the evidence against Donald Trump. That written reply is due October 17th. A minute later, when John Lauro once again referred to, quote, this sensitive time, Judge Chutkan had enough. Judge, wait, Mr. Lauro, yes, the judge. Let's just discuss what the sensitive time is. I understand there is an election pending, and I've said before, and I say again, that the electoral process and the timing of the election and what needs to happen before or shouldn't happen before the election is not relevant here. This court is not concerned with the electoral schedule. Yes, there's an election coming, but the sensitive time that you're talking about, if you're talking about the timing of legal issues and the timing of evidentiary issues in relation to when the election is, that's nothing I'm going to consider. The Trump team tried to throw another distraction at the judge that did not work. John Lauro told the judge he wants to file a motion to dismiss the case on the basis that Jack Smith's appointment as special prosecutor is unconstitutional. Justice Clarence Thomas was the only Supreme Court justice, that's 1 out of 9, who noted in his written opinion on the immunity decision that he also believed Jack Smith's appointment is unconstitutional. The opinion of one Supreme Court justice that is not part of the ruling in the case is, of course, immaterial, but it was enough for Donald Trump's favorite federal judge, Aileen Mercedes Cannon, who Donald Trump appointed, to reach the decision that Jack Smith's appointment was unconstitutional and thereby dismiss the criminal case Jack Smith brought against Donald Trump in Florida for illegal possession of classified documents and violations of the Espionage Act. Jack Smith is appealing that decision to the 11th Circuit Court of Appeals. The Circuit Court of Appeals for Washington, D.C. has ruled repeatedly over the years that the appointment of special counsels is constitutional. That means that Judge Chutkan is bound by the rulings of the appeals court in her jurisdiction. But she has, in effect, no choice but to rule that Jack Smith's appointment is constitutional. And nothing that Clarence Thomas or Aileen Mercedes Cannon has written seems to impress her. Trump's criminal defense lawyer told the judge, Justice Thomas wrote a very persuasive concurrence that suggested that the special counsel does not have authority. And in addition, another judge, a very respected judge in the Southern District of Florida, wrote a decision dismissing the special counsel's case on appointments clause basis and also on appropriations. And it is a critical issue that now has to be decided by the court in light of Justice Thomas's interest in this issue and also in light of what the judge decided in the Southern District of Florida. It seemed Judge Chutkan could not quite believe what she was hearing. She repeated to Trump's lawyer what he was asking for, which made it sound all the more preposterous. The judge, you want to file this because there's dicta in a concurrence? There's binding D.C. Circuit precedent on this issue. You have dicta in a concurrence written by Justice Thomas, and you have an opinion filed by another district judge in another circuit, which, frankly, this court doesn't find particularly persuasive. So that's your basis for seeking to file that motion? Mr. Lauro, Your Honor, we couldn't file the motion because of the circuit court decision. The judge. So is your argument that another district judge in Florida, that opinion, plus dicta in a concurrence in the Supreme Court, those two things combined to warrant me going against binding D.C. Circuit precedent? Mr. Lauro, what I'm saying is that the court should consider this issue, and Justice Thomas, in effect, directed us to raise this issue and suggested that we do it immediately in light of his view in that concurrence. The judge, he directed you to do that? Mr. Lauro, well, I shouldn't say he absolutely said, do it. But when you read that opinion, it's absolutely clear that that's something that we have to do now to preserve this issue. The judge, well, I certainly don't read the opinion that way. There is no suspense. on how Judge Tanya Chutkan is going to rule on that motion, arguing that Jack Smith's appointment is unconstitutional when it does finally reach her consideration.